I'm going to turn it over to Beth. We'll follow up on the invention disclosure process proper.
Thanks, Dave. It's always nice. I give a lot of talks on campus, I like to say, and one of them is the patent talk, and so I could have talked for probably 2 hours about the patent stuff. So it's nice to have somebody actually get that kind of compiled down into a more workable. Nobody fell asleep. I usually have a problem talking about patents. People fall asleep. So today I'm not going to talk about patents. I'm actually going to focus more on the disclosure process and working with WRF. And just to introduce myself, I'm Beth Werner. I'm an intellectual property manager at WRF. There are 6 of us at WRF that work on looking at research on campus, figuring out if there are aspects to it that we can protect the intellectual property, companies might be interested in it. We all have different scientific backgrounds, so there are some people that specialize on the life science side, there are some people that specialize on the physical science side. There's one person who's the software guru, I like to say, and has really gotten to know copyright law in and out, and I do not envy her that job. Copyrights are super complex and ownership issues arise, and so computer science and programming is one of those technology areas that spans a multitude of intellectual property protection types, and that is a challenge in and of itself. So I'm not a lawyer, I'm a scientist. I got my degree just down the road here at biochemistry, and then I went to work at industry for a little while and ended up coming back to do intellectual property management at WRF. I tell people, I can't believe that they actually pay me to go talk to the scientists on campus about cool science. That's my job. I mean, I have to deal with attorneys too, and that's kind of the downside of my job, but the science part is just the neatest thing. So I would encourage everyone, feel free. You don't have to fill out forms. You don't have to go through official processes. You don't reach out to us. I like science, so talk to me about your science. We can talk about what you're working on. We can talk about commercial applications of what you're working on, the intellectual property pieces, and really get into the details. I'm going to start out by talking just a little bit about WRF. Have people worked with WRF? Who's disclosed? Anybody has gone through this process, disclosed a technology? Anybody? One, couple, all right, a few people. How about heard of WRF outside of we sponsor lots of things on campus? All right, well, more hands, that's good. So WRF is the first academic technology transfer office in the United States, and it was established in 1925 by Professor Harry Steenbach. He developed a method of enriching food with vitamin D through UV irradiation. And if you actually want to go see his original light that he used to create this invention that started this whole industry of technology transfer in this country, talk to Dave at Steenbach Libraries. They've actually got a display with the original lamp that Steenbach used to make this invention back in 1925 that started WRF. So it's pretty cool. I've been on campus a long time, didn't know it existed. Just saw it recently. I do recommend a trip down to Steenbach to check that out. We are not part of the university, so that makes us a little unique as compared to other technology transfer offices, which are embedded in the university. We're a separate non-for-profit organization. We support research on campus. We support research for the University of Wisconsin-Madison and for the Morgridge Institute of Research. And we do this by figuring out the cool science going on campus, which this campus is big. And so again, talk to us about science because it's really hard for us to meet every single person on campus working on the neat science. Come to us as well. And we're trying to figure out if there are aspects of the research that companies will be interested in commercializing. We don't make products. We don't sell products. We figure out, can we secure intellectual property rights around the research? Are there materials or other products developed in the research that companies will pay to get access to? They will take licenses from us around the intellectual property rights or materials, and they will pay us a portion of their product sales as royalty payments to us. We then turn around and give an annual gift to the university that they use to continue to support research, which generates more cool inventions, which we protect, we license, more research. So we call it the cycle of innovation that WRF is a part of at the university. We just announced this week the annual gift for this year. I don't know if people saw it. I think the university just put that out. $80 million to the University of Wisconsin-Madison, and that is for them to use as they see fit, again, to support professors, for faculty retention, graduate student training grants, lab startup funds. WRF money is in a lot of different places on campus, building projects. So it's a neat job, it's a neat organization, and a neat career. I'll make a plug for that too. I was getting my PhD, didn't know what I wanted to do, figured out I wasn't going to be a bench scientist, had no idea that jobs like this existed. So if you want to talk to us about that as well, again, feel free to reach out. We're happy to do that. We've returned over $3 billion. I actually think that number's a little low, and I probably should look it up and see if it's a little bit bigger than that. But $3 billion in revenue to UW-Madison since its inception. So WRF does give a lot of money back to the university, and that's all due to the neat science on campus. I think Dave mentioned the different types of intellectual property, and I'm not going to go into that because I do want to have the equity review people have time to talk about their process. A lot of what we do is patenting. Inventions, patentable inventions on campus. It's probably 75 to 80% of what we're working on are securing patents on patentable inventions. We do register some copyrights. So David mentioned copyrights are interesting in that you don't have to federally register your copyright. Once you have a creative work and it is put in tangible form, that can be computer code as well, the copyright exists. So put the little circle C, put the year, put your name, the copyright exists. If you want to enforce your copyright or you want to try to license access to your copyright, you're going to want to register it with the U.S. Copyright Office, and we can do that. We have the experience to do that. Trademarks are another form of intellectual property, and WRF doesn't do much in the way of trademarks, and we don't because, as I mentioned, we don't make products. So trademarks are tied to descriptives, slogans, logos, colors, sounds, all associating and building a brand around a product that's used in commerce. And that used in commerce is a requirement to get a trademark. So the few trademarks that we actually register and control access to are around inventions that were created where the professor or the student has created the cool name that gets associated with that technology, and the company licenses the patent to the technology and then also wants to license access to that name. So we will register trademarks in those instances. The example I like to give, I manage the cranberry portfolio. We have historically had a very active cranberry research program on campus. When Dave mentioned plant patents, that is one example that is plant patentable. So I do secure plant patents on cranberries. And the breeders give the scientific name of the cranberry, this little code thing that means nothing except to the breeder, but they also come up with a really catchy name like Sundance or Ruby Star. And those are things that we will actually register the trademark around the cranberry name and license the trademark and the plant patent to growers in the state to produce. All right, patents. I think I'm just going to skip over most of this because Dave covered it, and I will point out that on average, just in the U.S., it runs WRF $30,000 to secure an issued U.S. patent. So as Dave mentioned, this is an involved process. Most of that is in attorney's fees. It can take us anywhere from 2 to 5 years to secure an issued U.S. patent. I think the longest I've had is 9 years to get it through the system and actually get the patent to issue. So this can be a process and it can be costly. And it's something to consider when you're thinking about technologies and protection. The different intellectual property protection, there are different strengths, there are different weaknesses, different lengths of protection time, and different costs associated. So when you're thinking about a technology, I like to encourage people, don't just think a patent. Think about intellectual property protection as a portfolio to give you a lot of different protection around a technology. I'm going to skip over the requirements here because I think we talked about them. The eligibility thing, I will point out, so it used to be, Dave's totally right, usefulness, utility is the low bar in this whole process because seriously, you guys are doing cool research and it's all useful. So that's never been an issue for us. Supreme Court decisions over the last 12 years have raised some issues around what is eligible for patenting. So it used to be that isolated DNA was something that you could get a patent on. That is no longer the case. And because of that decision, the Patent Office has now decided that isolated purified natural proteins, isolated purified small molecules that are products of nature are also no longer patent eligible. So we're actually seeing a lot more rejections from the Patent Office telling us we can't have a patent if we're playing in the natural product space. Diagnostics is another space where the Supreme Court had a court decision, and again about 10 years ago, that really threw a monkey wrench into our understanding of what is patent protectable in diagnostics as well. So won't get into the weeds here. If you're working in those spaces, don't lose hope. Come and talk to us. There are usually ways we can work with the Patent Office to secure patents on those technologies too. The heart of the talk is the IP management disclosure process. So this is our nice cartoon diagram of what we do with intellectual property. And the first step in this process, if you're going through the formal process, is to fill out an invention disclosure report form. Now, I didn't bring a copy of that form. It's about 4 pages. I like to tell people spend 30 minutes, maybe 45 minutes. You don't have to spend hours working on this, including all of your data. You know, if you've got a manuscript already drafted, you've got a poster already to be presented, you've got an abstract you're looking to submit, include that in that description of the invention section so you don't have to rewrite all of that. So save yourself as much time as possible. What we really want this form to do for us is give us an idea of what the technology is. We'll do some of that searching that Dave was talking about just to get ourselves sort of a background of what's in the space, what other people are doing, because we're going to meet with you ultimately to go over all the data. So again, enough detail. All the funding agencies get copies of the invention disclosure report forms that the equity review people, who will be talking in just a little bit, determine that funding's contributed to the invention. The funding agency gets the copy of the invention disclosure report form. I have had the NIH call me up and say, I don't have enough detail about this invention disclosure that was submitted. So you need to provide more information because it was only 3 sentences in a paragraph, something like that. So they do pay attention to that. And we do need to have a little bit of detail and a little bit of meat so they know what's going on. We are going to ask you what makes it better than what's out there. That is perhaps the hardest question we have to answer at WRF. I can usually tell you, can we get a patent? Can we not get a patent? What are the chances? What are the costs? That part of it. Can we find a commercial partner who's willing to pay and develop the technology? That's much harder. And so we're going to ask you, you're the scientists, you're the experts in the space, how does it compare to what else is out there? And we really want you to sell us the technology, sell us what the benefits are. We are going to ask you, when did you think of that invention and when did you first show that it worked? And those dates are important for this equity review process I've referenced a couple of times that I won't get into the details. But ultimately, we have to figure out, we're also going to ask you to take your best guess at who funded the work. And that's really important here at the University of Wisconsin-Madison because as part of your employment as students or faculty or staff, you did not, in your employment contract, assign all of your rights to IP to the UW-Madison. Most other universities, as part of employment contracts, they do have that language in their employment contracts saying you're going to assign all your intellectual property rights to the university. I tell you, if you work for a company, I can promise you it will be in there probably 3 or 4 times on how you are assigning all of your intellectual property rights to the company. So for us, the obligations around right assignments and can we patent things and can we license things, it's tied very strongly to who funded that research that made that invention. And that is one reason why the equity review process, where we've got people at the OVCRGE, I think I'm still pronouncing that right, we've got people there who do this job to make the final call on that, and I don't envy you guys your jobs either. And it's really important. So if you do get contacted by them, please help them out because we really need to know what funding agencies, are there third-party funders, are there company sponsorships, anything like that, because that's going to potentially impact can we patent and license the technology. We're going to ask you who the inventors are. Inventorship's a question of law, and I won't get into the gory details of how you determine who an inventor is. For this section, you're not lawyers. I'm not a lawyer. Who contributed a lot to the invention? Think of it that way. Who really made some significant contributions to the invention? List them. If you're doing copyrighted work, list who wrote the code, who wrote a manual, who was the one that actually created the film that you might want to register your copyright, who are the authors of that copyrighted work. List them. Really what we want to know is, do you work with people outside of the University of Wisconsin-Madison? Because if you do, we may end up having a jointly owned invention or a jointly owned copyrighted work, and we're going to have to figure out how to share costs and how to share revenue with that co-owner. So that's a lot of what we're looking for in that section is just, are you working with people outside of the University of Wisconsin-Madison? But put whomever has contributed a lot to the invention into that section. And we're going to want to know if you're going to publicly disclose your invention. And I got to tell you, that's the hardest part of our job is you guys talk about your research all the time. And David mentioned prior art. He mentioned novelty and obviousness and how your own publications and public disclosures can impact the ability to patent research. Fortunately, in the US, we have a 1-year grace period from when you first publicly disclose your invention to be able to patent it. And that's great. The rest of the world is not as kind. So if you volunteer all of the details of your invention and teach people how to do it, they say thanks, no patent for you. So just keep in mind that certain technologies, the international markets are really important. And if you've already publicly disclosed your invention before we file on it, we've lost the ability to pursue patents in a lot of the international markets. To highlight that. You're going to submit that form to either the IP person you work with. We have a portal that one person manages, so you can submit it electronically through a web portal. reach out. Anybody can figure out who should get these invention disclosure report forms. They'll get to the right person. We'll set up that meeting. That's our disclosure meeting to go over the details. Once a month, WRF has a disclosure decision meeting. That meeting is made up of an internal committee at WRF, the IP staff, the licensing staff, senior management. There's probably a group of about 25 people that review all of the inventions disclosed to us over the month. And that committee's tasked with deciding what we're going to accept for protection and licensing or what we're not. All right, and so our accept rate runs at about 50%, and our criteria is kind of the breadth of the protection. How strong would a patent be? How broad would a patent be? Is it something we can enforce against other people? Will we know if people are practicing it? Those are the questions we ask. The strength of the IP protection, the likelihood of finding the commercial partner is the other piece. And as I mentioned, that's a much harder question for us to answer, but it's certainly something we consider. You ultimately will get notified from the IP person working on your case whether the committee's decided yes or no, all right? In the meantime, all of the invention disclosure report forms that are submitted to us get sent on to the OVCRGE's office, and they are making their way up right now to give you an idea of the equity review process, and again, how important that is in figuring out that funding question.
Talk to you a little bit about the equity review process. So Beth's talked a lot about what happens up until WRF makes a decision about whether they're interested in pursuing patent on your invention or not. Regardless of whether WRF is interested in pursuing patent on your invention, all of the inventions that they discuss at that monthly meeting get sent over to our office. So Lee Jankowski and I are the two intellectual property disclosure specialists here at the University of Wisconsin. And what we do is basically they've looked at commercial viability, protectability, those sorts of things. We're looking at what obligations does the University of Wisconsin potentially have to outside parties related to that invention. So, things that are included in this process. We have to look at the IP language in any agreements for any funding or materials that may have touched that invention. So those could be grant agreements, they could be other kinds of industry cooperative agreements, they could be material transfer agreements or data use agreements. There are many kinds of agreements that could be involved. And what we're looking for specifically are intellectual property or invention clauses. Those clauses can say that we have to report inventions to that sponsor. They can say that we have to license anything that we patent back to them. So there are a lot of different nuances of what that can include, and we'll be looking for basically any of that. We also look at all payroll associated with the disclosed inventors. So when you fill out that disclosure form, you're listing all the people that you feel are inventors, and that's basically our starting point. The other piece of our starting point is the dates that you've given. And I think Beth mentioned this a bit, or it may have been David actually. We want to know when you first came up with the idea for your invention and also when it was shown to work or reduced to practice. And the time in between that is what we call the inventive period. That's when you really worked on it, showed that it worked, and in that time you probably were paid, although possibly not, especially as students. You may have used materials in order to test or create something. So anything that you may have used in that period is what we're looking at to look at those terms. Payroll is sort of the big obvious one. If you were paid on a grant, chances are that grant may have touched that invention in some way. We'll frequently, Beth mentioned this as well, we'll have correspondence back and forth with the inventors. And it's very important that we hear back when we send that out. It may seem, I think there's often a little bit of confusion between WRF's role and our role in the process. So you've probably already had discussions with WRF, you've answered a lot of questions, you're probably thinking, I'm pretty sure we already talked about this. Why are you asking me again? That's one we get. The other one we get is WRF isn't pursuing our invention, so this doesn't matter, right? But it does, because the university's obligations under a funding agreement stand whether or not we pursue patent on something. We still have an obligation in that intellectual property, because the intellectual property still exists regardless of what we're going to do with it. So we really do need all those answers, even if it seems like you don't understand why we're asking them, and always reach out and ask us why we need to know or how it fits into the process. We're happy to answer questions, we're happy to educate and learn more about what what happened and how the invention occurred so that we can do the best possible job pulling in the right UW agreements. Leah's going to talk a little bit more about what happens if there are no relevant agreements.
So Kristen talked a little bit about why we need to do an equity review and what that all entails and the different records that we're looking at. So you might ask yourself as an inventor, so what do I get at the end of that process? And what you get is what we call an equity review findings letter. And this letter, it comes from the Office of the Vice Chancellor for Research and Graduate Education. And it will essentially summarize what the obligations are that are associated with the invention. So it could very well be that we found that there were no obligations associated with the invention, in which case you would just get sort of a simple letter indicating as such. However, if we find in our review that there were maybe federal funds that supported your work that resulted in the invention, or maybe materials were used that are associated with an agreement that has terms and conditions that we need to be aware of, all that is summarized in the equity findings letter, which is sent out to all the inventors at the same time. And when that happens, what we're looking for the inventors to do is to review this information, take a look at the grant information, take a look at the names of the inventors. Let us know if we need to add someone or if we need to modify the grant information. Maybe you want to add additional grants, or maybe the initial information that we received was, maybe not correct and we need to change the grant information. But at the end of the day, our hope is that the inventors take a look at this letter and review it and let us know if there are any corrections. So the inventors have a 2-week period from when letter out. This is a review and comment period. So at that time, we're waiting for the inventors to get back to us so that we can modify it if need be. Now, if we don't hear from the inventors in that 2-week period and that 2-week period passes, then we will assume that what we found in our findings, that information is correct. And we will proceed accordingly and report it to the applicable relevant funding agencies or perhaps the other sponsors that contributed to the invention. Then we proceed with a third-party reporting. And Beth mentioned for federal grants that support inventions, there's a mechanism to do that. And part of that process includes providing the invention disclosure report that contains sort of the meat of the science, novelty. We also may potentially have to report it to other non-federal sponsors, again, depending on what we found in our findings. An example of that could be industry funding. So I don't know if you guys do a lot with industry research, but oftentimes it makes sense, right? These are for-profit companies and they have terms and conditions that are closely tied to intellectual property. They want to know if we gave you money to do research and if you invented something or came up with something, chances are they're going to want to know about it. But we figure out the details based on what the contract language states. And so lastly, once we do the third-party reporting, we finalize the equity review. That letter is essentially stamped finalized. We send it off to WRF. They see what our findings are. We also send it off to the Office of Research and Sponsored Programs, again, assuming that there was sponsored funding that supported the invention. And we do that because that office is responsible for monitoring and closing out grant activity. And so that is essentially the gist of what the equity review process is on a very high level. Myself, Lee Jankowski, and Kristen Harmon, we are in the Office of the Vice Chancellor for Research and Graduate Education. Up there, but if you guys have more detailed questions regarding that process, please we'll be at the tables later. I'm going to turn it back to Beth.
You both. All right, to finish up the process here, we'll talk about, well, First, the working with the attorneys parts. And I will say I get to pick attorneys to work with. We generally hire local IP attorneys. We can hire attorneys from anywhere in the country, and we do have some really great attorneys we work with. All of our legal work around patents is done by outside attorneys, so we're not drafting the patents ourselves. We hire the attorneys to do that drafting, but we're gonna have them meet with you. So we're gonna sit down, go over that data again. I'm gonna pick an attorney that is a technical expert or at least well-versed in the technology area you're in, so they should scientifically have a real good basis to talk the science with you, because we've really got to get them to understand the science so they can write a nice, strong patent application that's going to withstand this really long, arduous process of getting it through the patent office. We'll file it. It's a lot of hurry up and wait to this process where we're trying to beat deadlines, and then we file it, and then it sits at the patent office. And usually in the life science space, it's taking them about a year and a half to 2 years to even pick an application up and start to look at it, because there is a big backlog of applications, so it is kind of a slow process. The other thing that's going on is we're filing this, we file it, and then the licensing staff at WRF can start to market and try to find licensing partners for the technology. So we actually have a communications team with technical writers on staff. They will write up some of the marketing information for your technology. They might reach out to you to ask you again for some help. And the licensing staff's out there talking to their commercial contacts, trying to find that commercial partner that will spend the money on a license and the development time and resources needed to turn it into a product to actually get it out to the market. I always think that's one of the coolest things, is when one of the technologies I took in from the very beginning actually gets to be a marketed product, and I can find it on the web and it's for sale to people. I think that's pretty cool. So that's the process. I'm going to close with one quick slide, because I do get a lot of questions about this rights and what are my obligations and how do my rights flow. And I don't know if this helps or if this just confuses the issue even more. But again, I just want to reiterate that as inventors, you own your IP rights here. The only caveat being if there's funding that's contributed to that invention, and that can sort of make the rights flow into different buckets. Most of the research on campus is federally funded, and as such, you disclose your invention to WRF. WRF gets the first take at saying yes to it. So if WRF says yes, you have an obligation under federal law to assign your rights to WRF because of that federal funding. So that's the Bayh-Dole Act. Maybe you've heard of it. It was enacted in 1980, and that gave universities the right to take title to inventions. So we get the first shot. If we say no to a federally funded invention, the rights revert to the funding agency. So the government has the right to file a patent application on your invention. Could be the DOE, could be the NSF, could be the NIH. If you, as the inventor, think, WRF, you're wrong, and I will fully admit we are not 100% right, 99% right maybe, but we're not 100% right, so we do miss on technologies once in a while. You feel like we missed it. We should not have rejected your technology. You think you can patent it or protect it, and you've got contacts in a commercial entity, or you want to start up a company around it. There's a route for you to petition the federal agency that funded your invention to get your rights back so that you could proceed. In order to know whether you have to do this, you have to submit that invention disclosure report form. It has to go through the equity review people so that we know what federal agencies you need to work with to do that. If there is no funding, there's no federal money, there's no third-party money, it was somebody wrote a check for you to do some research, you have the option. You can disclose it. You disclose it to WRF. WRF could say yes, and if there is no funding, and again, you'll get that letter from the equity review people saying no funding contributed to this invention, you can tell WRF thanks but no thanks. You still have the ability to take it forward yourself if there is no funding that impacts how you have to assign your rights. That's, again, why it's really important to have that equity review. Like, let's say you've got a technology and you want to start up a company and you want 100% of the revenue. You don't want WRF to be taking a part of the revenue. So our deal is you assign your rights to us, we foot all the costs, we do all the marketing, all the legal, we license it back to your startup company. You, the inventor, would get 20% of the licensing revenue that we take in. 15% goes to the department of the inventors, and the rest goes into the WRF endowment, and that's where the gift comes from. But let's say you don't like that deal. You think, I can do this myself, I'm going to start up a company, I want 100% of the revenue coming in. I don't want to be sharing any of it with WRF or anything like that. That's a possibility for you, but you need that clearance. You need the clearance from the university to confirm that there is no obligation around your rights, that they didn't find any funding, they didn't find any other agreement. So again, disclose your inventions to WRF. even if you're not sure you want to work with WRF, get it into the process, because that's going to make your life a lot easier if you do have successes after the fact. The other little bucket is if there's third-party foundation, nonprofit foundation funding, Michael J. Fox Foundation, Cystic Fibrosis Foundation funding, sponsored research with companies, there will be language in those funding agreements around who gets the rights, what the obligations of WRF are to the entities that helped fund that research. All things we have to consider when we're looking at inventions and taking them in. So that's just a little bit of information around rights, because like I said, I know that a lot of people do ask about it and kind of how that all works. So with that, I'm past time, right? Because I always ramble a lot, Alyssa. Is that
You're good.
I'm good? Oh, well, that's pretty good then. I think we'll do questions, yeah?